No, it's outside, I think.
Call prize.
Yes, Mr.
May it please you. I mentioned before the lunch break that an affidavit had been sworn, and I also mentioned that we do have copies. Now, I don't know whether, my lady, your lordship, would be interested in seeing it. I mean, I've taken you through essentially what the content is. I don't think there's anything that
If you would like us to see it and Ms. Bone has no objection, we'll have a look at it.
Yes.
We may not spend very long on it, but it would be interesting to see, and you're entitled to show it to us if it was before the judge. At least we can see how detailed it is and what the subject matter
Indeed.
is. And so
I thought it would be of some assistance, so I turn to Ms. Bone to see whether there's an objection.
Well, my lord, it wasn't before the judge. The judge ordered that an affidavit be produced.
Oh, I see.
So with that clarification, I'm not going to make a formal objection.
No, right. Thank you very much.
I can ask that over Lawrence.
Thanks very much.
Thank you very much.
It says what it says, but there has been, understandably, some comment about suspicions or what have you, but I do say that that's actually the best evidence, really, if you like, as to certainly what's happened since the interim application. I don't need to dwell on it beyond that. What I would, and I proceed, perhaps I should have set it out at the outset, I'm proceeding on the basis that you have had a chance to read through my skeleton. I think that was the indication, and I picked that up during the course of today. But with that in mind, I'd like to first just touch on some factual disputes, and it's the nature of a case like the present, an interim application that has been appealed, that there remains a lot which is actually in dispute, which is properly to be determined at a full trial. And I've touched on some of it at my paragraph 3 of my skeleton argument, the second page. One of the central issues is whether or not ServiceNow is a key competitor. That's not for me to take that any further, but it is squarely in dispute. And of course that would inform whether or not at a final trial, it would inform the approach certainly to the reasonableness of the covenants. Now, you'll see from Mr. Gilligan's statement, and he talks about drop-down lists and Planon not being there, ServiceNow not being there. Another point which I should come back on is the contention that he oversaw 30 accounts. Now, as the court is already aware, when he began in 2015, his role was not managerial, but in 2020, at that point, he became a manager and he oversees people who are responsible for 30 accounts. So there's a point of distinction there. As of 2021, he himself was not dealing on a day-to-day basis directly with those accounts. He was overseeing people who were dealing with those accounts. But another point on instruction is that Planon doesn't just deal with facilities management. But that just gives you a flavour of the facts that remain and would need to be properly determined in this case.
Is that a point he makes in his witness statement, the defendant?
Which point, my lord?
That Planon doesn't just deal with facilities management.
I don't know. As I said, it was on instruction. I don't know that he squarely deals with it, but I can quickly double check. Bear with me. Certainly the point in relation to not being a major competitor is there. I'm looking at, of course, the supplemental bundle, and it's page 71 thereof. Two statements by the respondent, of course, are at tab 16 and tab 18. Certainly there's discussion of business opportunities and the extent to which he was involved there. Paragraph 11 on page 73. The point that I did make about whether or not it was a key competitor is at paragraph 14 on page 74. Turning to the second statement.
What CRM stand for?
Pithily, customer relationship management.
Thank you.
I think the answer to your lordship's question is it's not there, but as I say, it's a point that was made to me on instruction, and to be added to the list of facts that remain open. I propose, if I might, to come back on some of the law at this juncture. And my overriding submission is there's actually next to nothing really between the parties on the law, other than I say you can distinguish Yale and Newell, and they're not really of any great assistance to you. If I could firstly address you in relation to the case of Yale, it is Delivery Group and Yale, it's tab 3, and 2 points which I say clearly distinguish that case from the present. Firstly, dealt with, it's been touched upon earlier, it's a non-deaning covenant in that case. We see that at the bottom of paragraph 2. And then at paragraph 16, the facts in relation to that case were that the competitor, Whistle, was setting up a standalone business unit which was effectively a carbon copy of Postal Choices, staffed by former members of it. So a serious series of evidential basis for the proposition that serious breaches, and I say on any view, the evidence doesn't get anywhere near that in this case. Perhaps at its highest was the contention that my client had been somewhat evasive in the initial communications. I'll come back to that in due course in relation to the question of delay when we can look at some of the correspondence. But not setting up a carbon copy of a business and actively poaching staff. In relation to the case of Newell, which has been cited to you, again, the case I say respectfully that turns on its own facts and is not, doesn't stand as any proposition of law or any proposition of law that advances what we know from the other cases, including Herbert Morris and Coppage, which I'll turn to in due course. My learned friend did pray in aid, however, law by design, and if I might refer your lordships to the judgment in law by design, that's at tab 4. But once again, and I hope I can answer some of the questions that were raised about facts in that rather long judgment as I go through, but I say it's clearly, again, it's distinguishable. It's a long way away from the facts of this case. So if I could refer your lordships to, my lady, to 58, page 58, paragraph 22, Lord Justice Nugee picked up on the point that, and the question was asked, well, how senior was Miss Sally, what was her status? Well, the answer is that she was a director and became a director materially in April 2018. But we then see in the same page, usefully, paragraph 25, before the proceedings that were the subject of that judgment, she received a pay rise from £70,000 to £92,000 as consideration for entering into further covenants, just prior to the legal dispute that emerged. Now, in this case, some reliance has been placed on a pay rise that Mr. Gilligan received in May 2020 when he was promoted to his managerial position. And of course, again, the evidence seems to be in dispute there, because he says actually his pay had been increasing incrementally over a period of years, such that the increase at that juncture was only 10% or so. But
well, I think we're agreed, aren't we? Or I thought you and Ms. Boner agreed that the critical date here is 2020 and the amended contract is signed.
What I can say, there were two dates certainly that the judge was concerned with, and rightfully. It was 2015 when the initial contract was entered into, and then the amending agreement in 2020. If one looks at, and I don't know that I need to trouble you with it, but perhaps it might assist, the amending agreement, it didn't actually change the covenants in any way.
No, but surely if he signs an amended contract containing the same covenants, it wouldn't do you any good to show that in 2015 it was unreasonable if in 2020 it was reasonable.
Yes. I'm summarising essentially the judge's approach was that he didn't need to determine which date was the best date for looking at the reasonableness of the covenants, because it was the same point too with both dates. I come back to law by design, and we can also see, if I might refer you to paragraph 43, and this is just seeking to show why the case is so different to the current dispute. And again, there was an interim, there were undertakings offered, and then there was a trial. So again, we're not looking at the interim stage, we're looking at final trial of matters. We can see that paragraph 45 and indeed 43. But similar.
Is it a trial?
Well, there were undertakings offered, and then
the night before the hearing.
Yeah, deputy.
The hearing of the application, the hearing of the.
It was the hearing of the interim application.
Right.
And then from 45, the deputy High Court judge wasn't called upon to adjudicate on the merits of the application for interim relief.
Right. So the hearing before Mr. Beer was the trial.
Yes.
Yes.
But a further point of distinction, and this is really central, and it's similar to the Yeo case. If I could refer you, Your Lordships, my lady, to paragraph 82 and page 74 of the authorities bundle. The judge found as a fact that the defendant, Zaira Ali, had prepared a business plan which showed, and I'm just looking at the moment at point subparagraph A, to transition some 252,000 of the business over to waiting. Look at point B. It's clear that Ms. Ali proposed transitioning all of the significant clients. I don't know that I need to go further. This is again a million miles away from the present case. So I do distinguish those three first instance decisions, but I come back to my point that I don't think the law is actually in dispute between the parties. And it bears reminding ourselves of the Herbert Morris judgment and dicta at tab 12. And at page 707. Second paragraph in, looking at the test to be applied. First, it must be reasonable in the interest of the contracting parties, plural. And secondly, it must be reasonable in the interests of the public. There is an authority which you haven't been taken to as yet, but both my learned friend and I squarely relied on below, and that is the case of coppage, which is at tab 5. Indeed, I think we both set it out in full in our skeleton argument, which I say is a very useful distillation of the law in this area. And at paragraph 9 on page 86, the first point made, subparagraph 1, is that covenants and employment contracts are viewed more jealously than other commercial contracts. There's a series of cases where that has been developed. But again, subparagraph 2, it's the employer to show that a restraint is reasonable in the interest of the parties, and in particular that it's designed for the protection of some proprietary interest of the employer, for which the restraint is reasonably necessary. It does cite customer lists and other information about customers, which would fall within those proprietary interests. But at subparagraph 4, it makes the point that non-solicitation clauses are therefore more favourably looked upon than non-competition clauses. So there is, if you like, and we get it from the Office Angels case, if a covenant which is not so restrictive would suffice, then, and I ask the question hypothetically now, why was the claimant so keen to enforce or say that it was enforceable, the non-compete? Bearing in mind my observations at the outset of my submissions, the situation as we went into the court, albeit virtually, back in November, and the extent to which my client had acceded to what was sought. But then again, relevant to the discussions earlier today, but the question of subparagraph 5 on top of the second column, the question of reasonableness has to be asked at the outset of the contract, looking forwards a matter of the covenant's meaning, and not in light of matters that have subsequently taken place, save to the extent that those throw any general light on what might have been fairly contemplated on a reasonable view of the clause's meaning. I do rely squarely on coppage. I don't demur from my learned friend's submissions in relation to TFS derivatives and Morgan. As I said, I don't think there is much, really, if anything, other than perhaps what I've said earlier about those three cases between us. But we're concerned with the application of the law and the approach taken by the learned judge below. And you will see from my skeleton argument, and if I could refer you, please, to paragraphs 15 through to 16.7 thereof. And if I could ask you to have to hand the judgment itself, which is begins at page 55, of course, of the core bundle. Tab 4. And this demonstrates that the judge did approach this matter in a structured way, applying the law and reached conclusions that were perfectly open to him based on the material that was before the court. He set out relevant factual background. This is my paragraph 15. We can cross-refer, but it's there. It's set out in paragraphs 1 through to 8 of the judgment. He set out the relevant clauses. And yes, he didn't set out every facet of them, but he made the point that these are the most directly relevant. He analysed the impact of those clauses, not least, just to cite one instance of paragraph 15 on page 59, 17.1 falls into 3 categories: subclauses A and B, essentially non-solicitation clauses; subclauses C and B, essentially non-competition clauses; subclause E is, I would describe, a non-holding out clause. Importantly, he expressly refers there to the definition of a restricted business. While I'm passing paragraph 14, he makes reference to clause 17.4. So what I say to the point made earlier, that when we go further on to into the judgment, there was reference to 17.2, in particular I think it was 17.2c, and somehow that disappeared from the reasoning. Well, of course it didn't. This demonstrates beyond doubt that the judge considered and had in his mind, when he reached his judgment, made his orders, all of the clauses and all the material parts thereof. Thereafter, he set out the overarching legal framework that we have touched upon before lunch, paragraphs 20 and 21, so American cyanamide and ethicon, but with the need to look at, or to quote, to undertake some assessment of the merits applying Laing Lind. That's at the top of page 60. The judge looked then at whether there was a serious issue to be tried. That's paragraphs 22 through to 30, and as part of that element, that dicta, he also looked at and undertook his assessment of the prospects, some assessment of the prospects. We see paragraphs 31 to 32, as he should have. He looked at whether or not damages were an adequate remedy, and that specifically in relation to this claimant. He addressed the balance of convenience, cross-undertaking over the page, reached conclusions, and then went on and expressly dealt with the provision of information, and let's not forget the application for an order for preservation of documents. I say a structured judgment, relied on central authorities, and dealt with all the issues that he had to. My learned friend makes some criticism of the judge in particular, and it's repeated in a couple of instances in the grounds of appeal, the approach to reasonableness and the assessment of reasonableness. And again, if I can ask you to take up my skeleton argument, in particular paragraphs 47 through to 57, I think it's clear, but there is absolutely no doubt, and it's conceded that the TFS case was centrally before the court. There was no dispute. It was repeated again in both of our skeleton arguments. The judge was obviously aware of the need to assess the reasonableness of the non-complete clause. That was the clause that was centrally in dispute. He made reference, and it shows that he was aware of the need to look at legitimate interests of the claimant. Paragraph 50 and 51, where I set out the references there too. But that again, I remind the court that that had been conceded by the respondent, and indeed set out in detail in the skeleton argument below on behalf of the claimant. And he clearly, at paragraph 30, did consider whether or not the non-compete clause was wider than was reasonably necessary to protect the appellant's legitimate interests. He looked at the balance of convenience. And tellingly, and if I could go back to the judgment, at paragraph 28, a point that I touched on before, but it bears repetition, because the criticism is somehow, my own friend was clear about this, well, he got it wrong and he focused too much on the respondent. Well, so long as he looked at the impact, and the reason was in respect of legitimate interests of the claimant, he was entitled to look at the impact on my client. But importantly, at 28, he gives the clear direction that the time at which to undertake that analysis is as they stood in either 2015 or 2020. Not necessary for me to decide for this purpose which is the correct date to look at for the purpose of considering or deciding 17(1)(c) is or might be in restraint of trade. And he reached his conclusion that it may well be found that it was. But in the context of the law as it applies and applied to him, as I've set out just a few moments before in Coppage. So he was testing the position beforehand that he undertook his analysis as at the point that the contracts were entered into. And we see that at 28, and the use of the words, four lines in, 17.1c was always likely to have the effect of at least. So he is analysing it from the point at which the covenants were entered into. No error of law. Your Lordships, my lady, I've addressed you in relation to the evidence and indeed the fact that the judge could conclude that there was this oppressive impact of non-compete on my client. It's set out at my paragraph 66 to 70 for your note. But as I said again before the lunch break, that is what one takes from a proper view of the covenant properly construed. Before the lunch break, I also addressed you in relation to the discrete point about the application to see or have sight of the contract that Mr. Gilligan has with ServiceNow and the job description. I do repeat for completeness that actually it was still and is still open to the claimant to make that application. And it clearly was a material consideration that there were third-party interests and potential confidentiality in play.
Isn't Ms. Bone entitled to say, well, of course, Mr. Gilligan and ServiceNow are entitled to keep that card face down, but she invites us to infer from that that the risk of Mr. Gilligan being thrown out of work if the injunction is granted is not as great as you submit.
I think it's important to be clear, and Ms. Bone will correct me if I'm wrong, the way that this argument evolved. Essentially, on instruction, there was a sensitivity about the concerns of ServiceNow and that contract being viewed by Planon and others. That's where it came from. It didn't directly relate to my client, and that certainly was the position from where I'm standing. And I made that submission. I said there is a sensitivity, and then it was dealt with down the line. But it's not a case of actually this. It was just because Mr. Gilligan was saying absolutely no way. There was genuine concern for the position of ServiceNow, and the fact that it is arguably confidential what's said in a contract and also what's in the job description. And I think the affidavit does give the feel for the fact that my client is not hiding anything. and we remind ourselves that he acceded to all but job description, contract, and the non-compete. Because that clearly gave claimant more than adequate protection.
Does the, you say, oppressive nature of 17.1c and the potential hardship to Mr. Gilligan if it's enforced, does that go to stage 1 of the cyanamide analysis, serious issue to be tried, stage 2, adequacy of damages, stage 3, balance of convenience, or all 3?
It goes, well, I think different judges have put it in different places, but to my mind, it goes in with the serious issue to be tried. One is looking at, and at the same time, is there something serious that needs to be, will be the subject of a trial in due course? In this case, you're looking at the Lancing Lind, and you're applying that to it, and you're reaching the conclusions at that juncture. So it's separate, certainly, from the adequacy of damages, and separate from the balance of convenience. And that's the approach the judge took.
So you're submitting it's an issue that goes to the validity of the covenant?
Yes, that was what the judge was doing when he was looking at paragraph 28, whether or not, extrapolating ahead, undertaking some analysis of whether or not claimant's argument would be upheld at trial as to the reasonableness. He was undertaking that extra step, that extra necessary assessment, and the fact of this case, be it an interim application that on the face of it was likely to dispose of the claim.
The argument you're facing, as I understand it, is that if you look at TFS, you have these 3 stages. So you identify what the claimant's legitimate interests are, and then you ask, does this go beyond what's necessary? And that analysis doesn't really take account of the impact on the defendant. It's just looking from the claimant's point of view as to whether they've gone beyond what's necessary. So how does the potential impact on the defendant feed into the analysis of whether it crosses the line drawn in Herbert Saxelby that it's no more necessary?
Legitimate interests, I think, are accepted, and I hope it's not an issue that
Yes.
troubles the court. But the analysis at the serious issue to be tried, and that was the part of the judgment as well, you're looking at the impact on the claimant because you're looking at the impact on the interests of both the employer and the employee, and that's what Herbert Morris says, that's what Coppage says. And so it's the impact of this covenant. What would it have? And it is relevant that there were the other restraints of trade that had been acceded to. And did it tip the balance? Was it more than reasonably necessary to protect those legitimate interests? And that's what the judge was doing, and his conclusion was that might well be what the trial judge would find.
So have I understood correctly, you say that because it has a potentially significant, I mean your client's word was catastrophic, impact on him, that is something that can be taken account of in deciding whether it's more than necessary to protect the claimant's legitimate interest?
In the context where you have these other covenants essentially acceded to and accepted, is it necessary to go that extra step and have that potentially catastrophic impact, as you say, on my client? There is that balance. You're not in a vacuum looking at the legitimate interests of the employer alone. How does one answer the question, is it more than necessary? Is it beyond what is reasonably necessary to protect those legitimate interests? Well, the answer to the question is, well, yes, because it damages an employee who, within reason, is allowed to grow and mature and to accumulate skills and knowledge in the workplace and move on to new employment. That's where it goes, it's more than necessary. So that's the first stage. But it is also relevant, of course, to the exercise of the discretion.
Yeah, but that's the second stage.
That's the second. But to answer your
the
question.
criticism in Ground 1 is that the judge conflated what should have come in as a later stage with what should have been a very narrow focus at the first stage, which is whether it was more than necessary to protect the claimant's legitimate interests. And your answer is, no, you can't put it in a watertight compartment. It affects the analysis at the first stage as well.
Absolutely, and it's, and I think it's wrong to criticise the judge for that, because quite clearly what he was doing is he was doing that extra assessment that's necessary at the interim stage, pursuant to Laing, so it undertakes some assessment of the prospects. That's what he was doing in those paragraphs 26, 27, and importantly, 28.
Is there any authority that supports the idea that part of the analysis in considering whether or not a restriction goes further than is reasonably necessary to protect the employer's interest is a focus on the effect of the clause on the employee?
It's the impact on the parties. So I took your ladyship, I hope, and
No, I've understood the passages you've taken us to, but is there any authority where this point is actually in issue and argued and decided?
I think my learned friend and I would say absolutely not, maybe not completely clear cut, but it is. I do say it is squarely part of the Herbert Morris and the Coppage case.
Yeah, well, I've got that point. I'm just asking you whether it's actually been articulated anywhere in the way that you articulate it.
Well, my lady, I don't think it has to that extent.
All right.
There are different ways of looking at this, aren't there? If a court is deciding at trial whether a covenant is valid or not, the answer is either yes or no, and cyanamide factors don't come into play. But the approach taken in Lansing Linda, I think, was to say, is there a serious question to be tried? Yes. Would damages be adequate for either side? No. Then at the balance of convenience, they took into account what are the prospects of success of the claimant in upholding the validity of the covenant, and at that point the provisional judgment on the merits comes into play. Some judges do it the other way and say, is there a serious question to be tried? Is not a yes or no answer. It's sort of yes up to a point. I don't know whether it matters. The case law, as I recall, is rather unclear about where you factor in the provisional assessment of prospects of success.
I think a very important point is that the assessment is undertaken and that analysis is followed through. And it would follow that whether it be under the serious issue to be tried or balance of convenience, so long as it's undertaken and then the judge, he or she steps back and properly analyses applying the law, there's no error of law, and it would follow, I say, that it doesn't have to be absolutely that first stage serious issue to be tried. But there is overlap with the balance of convenience, because at the serious issue to be tried, what I'm saying is you're looking at whether or not the covenants go beyond adequate protection. But there's a separate analysis of the balance of convenience, because one's looking freestanding, the impact of an injustice down the line. So it's a slightly different approach, but it does call on similar principles. But what the judge did here under the serious issue to be tried, he was looking at whether or not the non-compete went beyond what was reasonable. And he concluded that he didn't conclude or bind anyone. He was express about that. As part of his sum analysis, he found that it may well be, and that's why he didn't uphold the non-compete when he came to his decision. If I might turn to the question of delay, if I could refer to my learned friend's argument, skeleton argument. It's the skeleton that was understandably put in yesterday. But
yes.
If I could ask you, please, to turn to paragraph 9 on page 14 of that. I've been calling it the delay bundle, but it's the additional bundle. And the proposition that the respondent has mischaracterised the period of delay as running from the date that he tendered his resignation, namely the 23rd of July of last year. In response to that point, if I could direct the Court's attention to Mr. Camp's first statement, which is at page 15, the supplemental bundle, and paragraph 51 thereof. And the reason for so doing is that I submit that this claimant should have acted way earlier than 2nd of September, because as of the 23rd of July 2021, during a telephone conversation, Mr. Camps actually raised the question of whether or not he was moving to ServiceNow. So it was clearly something that was exercising the mind of the claimant at the point of resignation. The next step, if I might, is page 45, still in the supplemental bundle, and it's the 2nd of August letter from Planon to Mark Gilligan. And I think this is actually a good distillation or summary of the response of my client. In the second paragraph, second major paragraph, whilst it's your right to keep your future plans confidential, it does cause me some unease that you were reluctant to tell me where you were intending to work for after 22nd of August. And then reference to Planon. We have the letter by reply, which begins at page 48. And then we see at page 50, at the end, I can confirm that I'm not intending to work for ServiceNow or indeed any other of Planon's limited competitors in a role that would place me in competition with Planon. That is as good as Mr. Gilligan saying, I'm not going to compete, and yes, I'm going to work for ServiceNow.
Well, except there's the passage in brackets, or indeed another of Planon's limited competitors.
Yes.
Well, it's an equivocation at the very best, isn't it?
It's not absolutely express,
No.
but it is followed the next day, and this is the height of the evidence against my client in terms of any potential breach, other than the fact that, yes, he did ultimately move. But the next day he's put on garden leave.
Yes.
And he was put on garden leave because the claimant was sufficiently concerned about an impact on its legitimate interests.
But Mr. Shepherd, you're not saying they should have gone to issued a claim and applied for an injunction in the first week of August, are you?
What I'm saying is that the period of analysis and the period of delay in this matter, I do submit, goes as early as the 6th of August, when they placed him on garden leave because they were clearly concerned about ServiceNow.
But they hadn't got any evidence that he's gone there.
That doesn't preclude an application for injunction, but I am saying I think it is right to say that at the very outset the claimant was clearly concerned and was concerned about justice ServiceNow. And
There's a difference between being suspicious and concerned and having the evidence that would justify launching proceedings. And you don't get a quiet time at injunction just by saying, I'm worried.
I accept that. But then the next step is, it clearly knew as of the 2nd of September, and there is an elapse of time between the 2nd of September and issuing the application that is being appealed on, in fact, the 22nd of October. That's when the application was issued. It's 1 day difference from issuing the 22nd of October 2020. And what the claimant says is, well, we were in the ordinary way trying to resolve matters. It's quite clear from the correspondence that in fact what the claimant was saying, you need to enter into these undertakings to the court or else there's not going to be any resolution. It was almost a fait accompli. And that persisted all the way through until the date of issue. And so insofar as it's contended, well, there were reasonable discussions, I say, well, actually, the stance adopted by the claimant was immovable.
But your client gave the undertakings at the door of the court the night before, apart from the non-compete clause.
Yes. Yes, he did. But looking at delay on the part of the claimant, I've heard the response to my submissions that one can look earlier, but certainly I say that the delay straddles from the 2nd of September until the 22nd of October.
How long do you say a claimant should take to get their injunction off the ground? Because there is validity in the point that if you jump straight into court, you get criticised for not trying to resolve it first.
But as of the 2nd of September, the claimant had had conversations, had asked him to enter into clear undertakings, had suspicions that he was moving to ServiceNow, and that was then confirmed. I would say at that point there'd been enough consideration and indeed effort put into this, including drafting quasi-legal letters, that it should have acted soon thereafter.
Soon after the 2nd?
Yes, the letter of September coming from Planon itself, or certainly the 2nd of August being from Planon itself. And indeed the letter of the 6th of August being from Planon itself. But dealing as I must with the submissions made, and Mr. Grant, of course, has provided a witness statement that we see in the further bundle. And what is said is, well, the trigger really for issuing so late was an email of the 18th of October, and that was the trigger for issuing a few days later. Now, this was touched on, but we do need to look at it. It's page 24 of this supplement, this additional bundle. And I say, in short, it's misleading to suggest that this was any trigger, or certainly properly construed was a trigger. At the bottom of 24, understandably, some of it's been redacted. There have been some discussions this morning.
Yes.
And the discussions to date have centred around their help desk, whoever that was, who managed all the hard and soft FM facilities management work. But then over the page, IT have decided to expand their use of ServiceNow and to take on desk booking module they provide. So actually, the client was an existing client of ServiceNow. Not the opposite. And this becomes apparent if we analyse it further on. The penetration, third line, the penetration on this prospect was not deep enough beyond the facilities management team, which is common, but still highlights we aren't that close to this prospect. So an existing client of ServiceNow that was only a prospect. And the next paragraph, 4 lines down.
What is desk booking module? What does that mean?
Software that you'll use to book desks.
I guess one can sit at a desk and can utilise the software to book in and take whatever information one needs. Nearly.
Is that facilities management? It's not, is it? It's something else.
It does seem to be a bit broader than that. But my point is that what one takes from this email is that this person, they were already a client of ServiceNow, and Planon would view them as a prospect only. And the next paragraph demonstrates, and 3 lines in, if ServiceNow decide to engage Nugee, who I understand are also a management facilities provider, on this client, I feel less positive about how we can win the smaller part of the core requirements, as the wider ServiceNow platform could cover all of their needs. So it's not, insofar as it's suggested, an indication that someone had tried to solicit a client. It's the opposite. It's someone already a client of ServiceNow being happy with the service provided. So I certainly say factually that, looking at that being the trigger, and I come back to my point about delay at the very least from 2nd of September to the 22nd of October, it is something that my learned friend accepts it is properly part of your consideration, exercise of discretion. And I say that elapsed time has not been properly justified. If you look at the correspondence in detail, certainly that last trigger is wrong to rely on it. And accordingly, that issue is squarely before you, and I do rely on it. I sought to address the legal authorities that have been discussed and were discussed this morning. In the context that you've read my skeleton argument, and I hope I've addressed you in relation to the tests to be adopted, I don't know whether I can assist the court further at this juncture.
Well, there was one other point that was taken against you, which is that if you were going to say, I'm going to lose my employment, your evidence wasn't really good enough.
I hope that's essentially the passage that I set out. I think it's 47. No, I apologise. It's under ground 6, and it's page 13. It's paragraph 66 through to 70. I did briefly address it before lunch, but the respondent provided the evidence, and I refer to it there, of the impact on him of the non-compete covenant. Evidence was also provided by the appellant through Mr. Camps as to the possibility of alternative work. It was submitted on behalf of the claimant that there was alternatives here as well. And there's no doubt that there was a niche area. And again, the point I made earlier, my client had been working for 6.5 years in this niche area. But that has to be coupled with looking at the covenants, the impact of those covenants, because that is what they translate to. There doesn't need to be, I say there is adequate evidence, but it's also the proper analysis of the impact of the covenant is that it would, as the judge says, likely have the effect that he would not be able to work, and I quote, in this area of the software market.
Well, Ms. Planon puts it in 2 ways. One is to say it would be easy for him to find another job. Speaking for myself, I don't think that has any traction. But her other way is saying that on a proper construction of 17.1c and 17.2c, ServiceNow could continue to employ Mr. Gilligan, provided that it wasn't in facilities management software. And in the absence of, for example, a letter from them saying, dear Mark, I'm afraid if this injunction is granted, we'll have to let you go, we should assume, and the judge should have assumed, that he would be able to continue working with them. What do you say to that?
Well, firstly, I say we've got the evidence from Mr. Gilligan that it would, in effect, lead to him losing his job. And we've got the proper analysis, because if you look at the carve-outs, essentially, he would not be able to work in this area, which here is a niche area of the software market, that he had been in for 6.5 years.
So except that as a matter of construction,
Yes.
stops him from selling facilities management software, it doesn't stop him from selling accounting software or desktop booking modules or whatever. That's what the contract means.
Well, Yes, the contract must mean the job that he was doing for the
Yes.
prior 6 months or 12 months. So it might encompass some of those additional elements. That's one of the factual determinations. But it prevents him doing the job that he was doing for Planon within a geographical, certainly within the UK, dispute as to whether or not that actually went to Ireland, but within the UK. And that's going to have an impact on anyone, whatever the job. But secondly, within the area that he'd specialised in for 6.5 years, it being a niche area. And I say it's a very simple step from that to the judge's conclusion that it was likely to have the impact of leading to him losing his job or being out of work for the duration of that non-compete covenant, coupled with the evidence of the impact provided by my client. So I say it was permissible conclusion from a proper analysis of the impact of the covenant and the evidence that was before Mr. Justice Edwin Johnson.
Some of what he says in paragraph 9 is a bit exaggerated, isn't it? Because he says, I need to earn a living. The claimant cuts me off completely from any work for 12 months. That's unfair to me and I feel unreasonable. But that's not the effect of the covenant, is it?
I think the point is being made, and I do say clearly that the impact of that covenant would lead to him quite possibly losing his job. I mean, the language is the language that he chose, but it is evidence as to the potential.
Well, but it conveys a meaning. I mean, he asserts that it would cut him off from any work for 12 months, and I'm testing whether that's at all plausible. It's about halfway down paragraph 9.
Yeah, I'm just there. I think in a layperson's terms, what he's saying is that, well, in terms, he's happy to agree the restrictions to protect the claimant's business, by which he'll abide, but he can't be left in a position where he couldn't work until August of next year, and that's clearly linking to his view of the impact of the non-compete, and then the impact being I need to earn a living, and if I'm cut off completely, it's unfair on me and unreasonable, and he sets out other impacts there on his broader family. So in layperson's terms, he's saying that is the impact of the non-compete clause.
Right.
I don't know whether I can address you further in relation to this point, or indeed anything else in my skeleton argument.
We'll just rise for a moment to see whether between us we have any more questions to put to you, and then after that, whether we do or we don't, we'll hear from Ms. Baird.
The live streaming remains on.
you need.
Court rise.
Right, thank you, Mr. Shepherd. I don't think we have anything else to put to you, so back to you, Ms. Bain.
My lords, my lady, I'm grateful. I have some short points in reply, which I will take as closely as I can in the order of the questions under the TFS test. It was my lady's question to my learned friend: is there any authority that the impact on the defendant is to be looked at? And the answer to that in my submission is not as the respondent now contends the impact is to be looked at, but Herbert Morris and Saxelby addresses briefly how the interests of the parties are balanced. That's at tab 12 of the authorities bundle. And in the speech of Lord Parker, it's at page 707, one of the highlighted parts of the speech. In the first full paragraph of the page, 2 lines down, the learned judge says, first, that is the restraint, it must be reasonable in the interests of the contracting parties, and secondly, it must be reasonable in the interests of the public. And it goes on to be reasonable in the interests of the parties. The restraint must afford adequate protection to the party in whose favour it is imposed. To be reasonable in the interests of the public, it must be in no way injurious to the public. And a little further down in the next paragraph, the interest of the covenantor is articulated. So 5 lines within that paragraph, so conceived, the test appears to me to be valid as both regards the covenantor and the covenantee. For, though in one sense no doubt contrary to the interests of the covenantor to subject himself to any restraint, still it may be for his advantage to be able so to subject himself in cases where he could not do so, he would lose other advantages, such as the possibility of obtaining the best terms of the sale on an existing business, or the possibility of obtaining employment or training under competent employers. So,
in other words, Lord Parker's treating this exposition as an exposition of what it means to say that the contract is reasonable in the interest of the parties.
my lady, yes.
And he's not in any way suggesting that it's got anything to do with the sorts of points that are being relied on in this case.
Exactly so, my lady. So the impact on the covenantor is not what happens when the covenant is enforced. The impact is what the relevant impact is what the covenant allows the parties to enjoy, which is a relationship of better confidence and the opportunities of better employment.
Well, there's also the famous passage at page 709, the employment lawyers are brought up. The paragraph beginning it is quite different.
My lord, yes, and it's a little below the top hole punch. Whenever such covenants have been applied,
Yes.
On this ground, not that the servitor of apprentices would, by reason of his employment or training, obtain the skill and knowledge necessary to equip him as a possible competitor, but that he might obtain such personal knowledge and influence over the customers of his employer, if competition were as allowed, to take advantage of his employer's trade connection, utilise information confidentially obtained. So my lords, the balance between the parties is as set out there in Herbert Morris and Saxelby. A suggestion was made throughout my learned friends' submissions that the non-compete covenant could be looked at more harshly because the other reliefs had been granted. Non-compete covenants are always looked at with a greater scrutiny for all of the reasons that I've set out already in my submissions, because they are more draconian. I accept that. But the test, the analysis to be undertaken, it is the same, albeit that it will be taken with greater scrutiny in relation to a non-compete covenant. So the fact that it has the character of a non-compete doesn't mean that a different weighing of the parties' interests comes into play, or that the aspects that my learned friend relies upon, the impact on the respondent of not being able to carry out that work and suffering hardship, comes into play in considering the reasonableness of the clause. Not being able to do the work that's prohibited within the covenant is the purpose of the covenant. So it's always going to be the impact of the covenant. And if that prohibition defeated the covenant, then they would never succeed. My lord, you asked at what stage in the exercise ought the Lansing-Linder assessment of prospects to be done, and the correct stage is at the balance of convenience stage. So at the end, the Yeo case looks at the practicalities of that. And this is behind tab 3 of the authorities bundle, and it's touched on at paragraphs 5 and 35. Going first to paragraph 5, the learned judge there notes that he's required to, because of the timing of the case, required to undertake an assessment as to whether they are likely to succeed at trial, contrary to the standard approach, which merely shows a serious issue to be tried. And in fact, it's at paragraph 8 where the learned judge goes on, I will consider the merits of the claimant's claims. It matters not that this issue is considered at the serious to be tried stage or as part of the balanced convenience stage, but it probably falls more clearly within the latter question. So the correct, doctrinally, the correct stage is that latter stage. But of course, what the court may well in practice find that it is doing is reiterating evaluations that have been made earlier on in analysing whether there's a serious issue to be tried. My lord, my learned friend urged you to distinguish law by design on the basis of the seriousness of the conduct in that case. And of course that's a point of difference, but it's not a point that's different in relation to the tests to be applied. The extent of the seriousness of the breach, following on from the submission I've just made in relation to the stage at which Lansing-Linder is to be considered, the seriousness of the breach is again not a matter for the TFS test, I'll put it in that way, it's a matter for the balance of convenience stage. It doesn't go to whether or not the covenant is likely to be potentially enforceable, but what response the court should have to it in the grant of relief or otherwise. And then going to the judgment, and in particular, your lordships and your ladyship were taken to paragraph 28 of the judgment. And of course, we have in this case the original contract and then the amended contract, which I say is the correct stage for the analysis to be undertaken. The fact in my submission that the judge didn't address that point, didn't make a conclusive determination on whether it should be 2015, whether it should be 2020, is a yet further sign that he did not have the proper test in mind. Because, of course, there had been a change in the respondent's employment duties. It was my submission that at either date, the covenant was good enough. But in testing that submission, the court, had it had the proper test in mind, would have said, yes, but he was junior, he was new. Really, did he have the same access to confidential information, the same depth of customer connection, etc., that he then had at the later stage?
It's a bit hard on the judge if you were saying whichever date is chosen, you win, and Mr. Shepherd was saying whichever date is chosen, you lose. Then you criticise the judge for not distinguishing between the two dates.
Well, my lord, to the extent that, again, points taken in relation to Ali being a director, being in a more senior position, to the extent that seniority is advanced as being a point of distinction to the facts of the present case, then the failure to engage with the difference in the earlier role and then the more senior role is a yet further indication in my submission that the judge was not looking at this through the prism of the appellant's interests, but rather the impact after enforcement on the defendant. And again, in this paragraph, it says that Clause 17.1c was always likely to have the effect of at least severely restricting the defendant's ability to find new employment. I repeat the point that I've just made, that that's the very nature of a non-compete, is that it restricts what competitive activity, what employment can be undertaken for the restrictive period. This is also a yet further indication of the judge's departure from the TFS test, from not having construed the clause first and then followed with analysis of reasonableness, because here the judge is latching onto 17.1c and not the whole of the clause, with that important second qualifier, which I say does so much to enhance the reasonableness of the restraint. In terms of, I think, addressing you really on the adequacies of protection and on the scope of the clause, my learned friend said that for some years the respondent had been in sales, in facilities management. In the supplemental bundle, page 86 is the respondent's LinkedIn profile. It begins so it's tab 20 and it begins at page 84. And page 86, your lordships and my ladyship will see it sets out the recent course of his employment history. So sales and then head of sales within the appellant from May 2017 onwards. Prior to that, an account manager. And then the job before that, at the foot of the page, in something the ITAD works, their role as an account manager in the IT change management industry. So a sales-focused role, but in a different industry. I'll ask you to take that into account in considering the ambit of the clause and the potential for Mr. Gilligan to ply his trade in other roles.
I've been meaning to ask either of you since the hearing began and forgot. EMEA, what's that?
that's EMEA, Europe.
Middle East and Africa.
Thank you. Right, good. Yes, sorry, you were going to take us to another page of the contract.
If you just give me a moment while I look at my notes. Moving on then to the submissions that were made in relation to delay. You've been through the correspondence, and I won't repeat the point that there's a delicate exercise to be done between not injuncting too soon and not injuncting too late. And I would urge your lordships, your ladyship, to consider the interests of the parties in the round, because it's a fallacy to think that delay is a pressure for the applicant alone. In fact, the need to act speedily can very often be to the detriment, particularly of more vulnerable defendants who have reduced means and who may not have the means to get the legal advice when the first letter comes, and who need an element of persuasion through that period of correspondence to understand the severity of the consequences. But for those consequences to follow hot off the press of the first letter would likely, in my submission as a matter of practice, hurt defendants more than it hurts applicants, who very often, now that there's a much more developed body of law in this area, a much more developed understanding, will be familiar not just with the broad rubric of the law on restraints, and will of course have discussed them with the lawyers who did the drafting for them originally, but will also understand what it is to apply for injunctive relief and the spike in costs that happens at the point of issue. A more cautious timetable in my submission will be far more to the advantage of defendants. To close my reply in relation to the delay point, it's a small point, but I do want to correct it. In relation to the 18th of October email that you've been referred to by both my learned friend and I, my learned friend said it was claimed to be a trigger point for the issue of the application. No, it wasn't. But what Mr. Grant did say in his witness statement is that evidence was surfacing only at a late stage, or only at that late stage, to support the application. And there's been some to and fro about what that email in fact means. You will have Lucian Camp's evidence, paragraph 62 and paragraph 71. That is supplemental bundle page 28. So at 62, Mr. Camp says this is an email from senior sales manager reporting how one of Planon's customers had taken a desk booking module, and notes that the name of the customer is redacted. And then the same point is made, paragraph 71, and it's at the top of page 30. Particularly as ServiceNow are winning our clients' business, see the email. This is why we also require full and frank disclosure from him in the form of an affidavit. So that's the state of the evidence on that email point.
Do you agree that a desk booking module is not part of facilities management.
May I turn my
Sync
back for a
was what
moment?
Mr. Shepherd said.
My Lord, thank you for giving me that moment. Yes, it is part of facilities management, because what a desk booking module is a facility to help in the allocation of desks in building. So I think it will link into hot desking and finding available space for people to sit and work. So all part of the management of the premises.
Thank you.
My final point of reply in relation to the question of discretion and the hardship point, and in particular coming from the question of your lordships and your ladyship at the end of my learned friends' submissions, and yes, indeed, the fact that the contract with ServiceNow is not disclosed, there's an inference to be drawn in relation to that. It may be a matter for my learned friend's instruction as to why it hasn't been disclosed, but that's not part of the evidence that's been put before you in this case.
Well, I think he was saying there was something about some sensitivity on the part of ServiceNow about the disclosure of or it was thought there might be.
That's not been put in Mr. Gilligan's witness statement as far as I can see.
Okay.
You've had handed up to you during the hearing the affidavit that Mr. Gilligan was ordered to provide by the learned judge below. But what he hasn't done is provided you with any further information about what his financial position is now. Because, of course, I invite you on disposal to set aside the decision that the order that the judge made not to uphold the non-compete and to uphold it, essentially to undertake the exercise yourselves. And I ask you not to exercise your discretion in relation to any claimed hardship, because there was not then and there is still not now any proper evidential basis to support it.
Well, you're seeking an order from us that Mr. Gilligan should be subject to an injunction not to be employed in facilities management software work from now till the 6th of August, in essence.
In facilities management software, in the duties of a sales account manager and product developer, and product development duties.
Can I just be sure, when you say we should not accept any hardship, is that because you say there isn't sufficient evidence that he would cease to be able to work? Or do you say that even if he ceased to be able to work, we don't have enough knowledge about his finances? He might have a secret store of capital to live on. Which is it?
It's both, my lord. It's both that the necessary consequence of a non-compete covenant is to restrict the ex-employee from doing a certain job. And so in enforcing covenant in these circumstances where Mr. Gilligan has chosen to take work that would trespass, and if trespass on the non-compete if it's enforceable, he has put himself in that position. And he knew of the covenant when he was working at Planon and had the opportunity to prepare himself financially for it. He's known of our application and this appeal and has again had the opportunity to prepare for it. Perhaps also there is the hidden wealth that you suggest. We don't know what his means are.
Well,
we don't know truly what hardship will befall him.
He says he has a mortgage to pay and it would be catastrophic for him. Ought we to go behind that?
My lord, I say that that's not good enough evidence.
What more do you expect him to say?
Well,
my outgoings was £1,700 and 52 pence a year. a month? I mean, can't we assume that someone in Mr. Gilligan's position is going to suffer financial hardship if he is unemployed between now and August?
My lord, I say not hardship such as to give rise to the exercise of discretion against the enforcement of an injunction. Otherwise, we're essentially putting an income threshold on the enforceability of non-competes. There are a fair few professions, there are a fair few occupations where earnings tend, in my experience, to be far lower than the present case.
Yes.
The paradigm, again in my experience, is recruitment consultants, often quite young and often on salaries of, say, £30,000. That may be supplemented by commission, but that's the luck of the job. But yes, still, non-competes are, first of all, routinely upheld, and second of all, are important to be upheld because that's a paradigm of an occupation where the employee's Rolodex or the contacts on the mobile phone or LinkedIn are absolutely central to the business. And any employee can simply walk out of the door with hundreds or thousands of contacts and the ability to port that business to a new venture. So the hardship factor needs to be considered very carefully lest it become a charter for contract breaking. It become a way for the ex-employee, the departing employee, to say, well, I'm going to have a gamble because I can position my finances so that the gamble is essentially on at risk of the employer, former employer. Unless I can assist you further, those are my points in reply.
Thank you both very much. It's been extremely helpful. We will reserve judgment. We're not in a position to say exactly when you will have a result. We're conscious of the fact that if we left it till close to the 6th of August, there wouldn't be much point in this hearing. But we will do the best we can to get to a draft judgment as soon as we can in the usual way, not for re-argument, but for correction of any manifest errors and so forth. Grateful to both of you.
Well,